Peace and tranquility are the prerequisite for development and smooth functioning in the society. If there is disorderliness in society or any other hindrance of like nature, the society cannot provide to the individual the opportunity to grow and develop to their full potential. Hence, the maintenance of peace and tranquility is a must for the society and the nation as a whole. Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company, and in this video we will discuss about the offences against public tranquility. Offences against the public tranquility are the offences against not only a single person or a property but against the society at large. These kind of offences are committed by the group of people sharing a common intention to disturb the peace and tranquility. Let's see the maintenance of what is maintenance of public peace. It is duty of the state to maintain public peace and order. It is even present in section 23 of the Police Act 1861 to maintain order in the public road and public places. In fact, it is an offence to cause inconvenience, obstruction, annoyance, risk, danger or damages to the public order or peace, and further section 34 of the Police Act 1861 makes the police responsible for maintaining public tranquility and punish anyone committing an offence. Hence, public order means that the action of the individual should not impinge the public peace or cause any kind of inconvenience to other persons. What are public offences? Under IPC Chapter 8, which deals with the public offences, provides 4 public offences, namely the unlawful assembly, second, rioting, third, enmity against different classes, fourth, affray. Let's start with what is unlawful assembly. Section 141 of the IPC 1860 deals with the unlawful assembly. Article 19(1)(b) of the Indian Constitution confers a fundamental right to assemble peacefully. However, this section seeks to criminalize an unlawful assembly. Let's see the definition. Assembly of 5 or more persons to commit an unlawful offence is to be called as unlawful assembly. An important aspect of the unlawful assembly is the presence of common intention to disturb the public peace and tranquility. The mere presence of a person in an assembly without any motive to infringe the peace in the surrounding is not punishable. The common objective is to determine the aim and nature of the assembly. It is also possible that lawful assembly turns out to be an unlawful assembly at times. What are the objectives? Basically, it is to use criminal force against any public servant, state or central government. Second, it is to resist any legal proceeding. Third, it is to commit any mischief or trespass or any other on any other person or property. Fourth, is to use any criminal force against any person to deprive him of the enjoyment of his rights. Fifth, is to use the criminal force against a person and compelling him to do something which is legally not bound to do. Now let's see the ingredient of unlawful assembly. There are several ingredients need to be present for making anyone liable for the punishment defined under lawful assembly. First, there should be 5 or more persons. Unlawful assembly should consist of persons more than 5. If the number of persons in the group is less than 5, then it will render the section inapplicable. Second, they all must have a common object. The term object refers to design or purpose, and for it to common, the person needs to share and abide by it. The members of an unlawful assembly must have a common object to commit a particular offence. Unlike common intention, here prior meeting of mind is not important. The common object should be constituted on the spot. Now the next is rioting. Section 146 and 147 under IPC deals with rioting. It usually takes place as a way to dissent something or on a perceived threat or grievance. Let's go by the definition. Where an offence is committed by a group of people or any person belonging to that group is termed to as rioting. For rioting, the presence of at least 5 people is necessary. This offence is generally grounded in civil unrest and is usually sudden and provocative behavior. It shows a hurt-like mentality, and this is a reason that in case if a person belonging to the guilty group has not committed a violent act, even then she will be liable for rioting. One of the most important ingredients is to constitute rioting in a common intention, an object of committing a crime. This very common intention make all the people in the group liable to be punished, even when they haven't even committed the crime themselves in the writing. The punishment for rioting is present under Section 148 of the IPC and the description of the term of 3 years or fine or both. This offence is cognizable and could be tried by the first class magistrate. And the punishment for committing rioting with a deadly weapon will be covered under Section 148 of the IPC. This section demands that same ingredient as that of rioting but with the addition of the deadly weapon. The weapon could be anything that is so dangerous that it can cause the death of a person. The punishment for this is imprisonment up to 3 years, which shall be depend on the impact of the rioting or with fine or with both. Now let's see the punishment for provoking a riot. This offence is present under Section 153 of IPC. Here, if a person with a malice intention to provoke someone knowingly completely that this provocation could lead to rioting, then that person would be booked under the Section 153. The person provoking riot has a malice intention and act voluntarily. Under this act, there is no need for rioting to actually take place, but only the mere provocation is enough to be liable for punishment. If rioting took place, then the punishment would be maximum of 1 year or with fine or both. And if the rioting does not take place, then the maximum imprisonment should be up to 6 months or with fine or both. Then the next is affray. It is defined in the section 159 and 160 of the IPC. Let's go by the definition. Affray refers to fighting in a public so that it disturbs the public order and peace. For affray to take place, the presence of 2 or more persons is a must, and their action should negatively affect the tranquility of the surrounding. However, most importantly, the effect of their behavior should create a disorder in the society. The punishment for affray could be 1 month or imprisonment or fine of 100 or both. Now let's see promoting enmity between the classes. This category of public offence comes under section 153A and 153B of the IPC. And according to definition, this section makes the promotion of enmity between different grounds on the religion, race, place of birth, resident, language, etc., which makes it punishable. The jurisdiction of this section is very wide and also includes offences on moral corruptions. The punishment under the section is of maximum imprisonment of 3 years or with fine or both. However, if the above mentioned offence is committed inside a religious institute, then the punishment would exceed up to 5 years or with fine or both. Now let's see the essential ingredients of section 153A. First being the promotion of enmity between different groups of religion, race, caste, residence, place of birth, community or any other group. Second being the act that disturbs the public tranquility and encourages discord between different groups or caste or community. Third being the act or object that causes fear or alarm or threat or insecurity for any religious, racial, languages or regional group or caste or community by the use of criminal forces of any sort or any sort of violence against them. Then there is mens rea, which plays an important role to hold a person liable for punishment under this section. Then the last being the presence of 2 communities is important to attack this section. Mere derogation of the feeling of one community without any reference to any other community is not considered under this section. Now let's see the scope of section 153A. In the case of Gopal Vinayak Gopde versus Union of India in Bombay High Court decided that it is not necessary that enmity or hatred actually arouse between different classes because of certain act or object. The matter, which comes under this purview of section 153A of the IPC, should be considered as whole and not by some stray or isolated part or portion. It is also necessary to consider the class for which the act or the object meant to promote enmity is subject to. The truth is no defense under section 153A. In fact, the greater the truth, the greater the impact of the mind on the minds of the people the act or object was subject to. Now let's see section 153B. This section was added to contain the rising disharmony amongst various communities. This was added in year 1972, which was a higher level tension where there was a high level tension amongst various castes, and this was affecting not only the social harmony prevalent in a society, but also was affecting the national integrity. It was published. It was provided on the publishers an imputation that certain person who belongs to a particular class, religion, race, caste, which cannot bear allegiance to the national integrity. Moreover, a certain group of people belonging to a particular caste or community are bereft of their right of citizenship. The last being any of the aforementioned act must perpetuate discord and harmony amongst the different classes of the people. With this, I would like to end this video. Thank you for watching. Please like, share, and subscribe.